We're often asked about drug possession and the charges and consequences. The starting point is always the law. What is the actual law that you've been charged with? Most drug offending comes under the Drugs, Poison, Controlled Substances Act, and there's definition of drugs, how much is a simple possession charge, how much is a different level, so a commercial quantity or a large commercial quantity. So the starting point is that. What is it that you've been charged with? What are the normal penalties that flow from that? What amounts to possession? Possession is where you are in control of something. You might have it on your person, you might have it in your premises, you might have it in your car. The court can draw inferences that you're in possession of it because of that. But that isn't completely determinative, because in a situation where somebody's been in the car with you and they've slipped it under the seat, that doesn't make you guilty of possession if you didn't know they were going to do that. So there's got to be a guilty mind. Mens rea is the term that lawyers throw around a lot, which just is really the guilty mind that attaches to an offence. The maximum penalty for possession simpliciter, so simpliciter just means simple possession, is 1 year or 30 penalty units. Penalty units are something the Parliament set every couple of years and they go up, but they're say around $120 per penalty unit. So the penalties at that stage are quite small. Those are the maximum penalties. That is not what you have to get. So if you think of an example of what a person is caught with, and then there's a really bad example of that, obviously the person with lesser is going to get a lesser penalty. So it's all about working out what is the factual matrix of your case. And in that factual matrix is the determination of whether you are possessing or trafficking. And the amount that you're caught with is often a clear indication of whether it is possession or trafficking. Caught with a pound of marijuana, it's more likely that you are trafficking. It's not always the case, but it's sort of clear indication to the court that it's highly likely. The reality is that some people don't want to have anything to do with drug dealers, and they buy in bulk and then they bag it out for the year's supply. And so that's the sort of thing that becomes a matter of submission or defending a charge if you're charged with trafficking when in fact you were just possessing. In terms of sentencing, there are a couple of important things. The caution and the diversion program. The caution program is one where the police themselves caution people and they don't proceed to even charge them. So you'll only generally get a caution once. If you're a young person and you're caught with a small amount of cannabis, the police are going to give you a warning, say, look, next time you do it, you're going to go to court. We'll give you this chance to avoid that process, and they send you on your way, which is great. And they normally would do that in a situation where you're compliant, you're polite, you don't cause them any grief. The second really important sentencing process is the diversion process. Drug possession can have lasting effects on people's lives, and both in a career sense and also limiting international travel. So you really want to try for a diversion, because a diversion means that the court agree that charge should be withdrawn against you on you agreeing to do something. So what that means is ultimately, if somebody says to you, have you ever been found guilty of a cannabis charge, you can say no, and that is truthful because the charge has been withdrawn and you don't have a criminal record of any type. which again is important for all sorts of obvious reasons with organisations that want to see that you have a clear record. And it also reflects the fact that the court, the police, have all agreed that this was such minor offending that they don't want it to be the cause of problems for you for the rest of your life. Another thing to take into account with drug possession is the court have a very wide range of sentencing options and factors they take into account. And there's a real complexity in sentencing because you're trying to present a person to the court and say, look, there are all these factors in their life and they're all really important. And you want to make that process easy for a magistrate. So if you're saying they've got a mortgage, it's big, it impacts on their mental health, they like to smoke marijuana every now and then, you'd have a copy of your mortgage statement. If you were saying they're working, you have a letter from the boss or from a co-employee. You give the court everything you possibly can so that they just accept all of this is true, what's been put to me. I'm just making a final decision, do I convict or not convict? And that becomes much easier for them than them having to worry, well, they're saying this about this, I don't really understand it or I'm uncertain about it. So you want to prepare these things fully. You want to make sure that you take every opportunity that you can. And it's about communication with your lawyer. You want to be talking to them getting to know you and them understanding what the good things about you are. Like your partner or your mother might come along and they're saying, well, Johnny mows the lawn for his neighbour once a month. He doesn't get paid for it, but they're a nice person, the neighbour. That sort of thing is important for us as lawyers because it personalises you. And we can tell a magistrate, look, this is what he does. Most people don't do that sort of thing, so it gives you some indication of what a person's character is. And you're wanting the magistrate to see your client as a person, who they are, emphasising the good things about them. And you only get to that point if you spend a lot of time talking to your lawyer and engaging with them. If you can't engage with your lawyer, if you come and see me, you don't like me, go to a different lawyer. It's as easy as that. You want someone you're comfortable with and somebody who you understand what they're trying to do to help you. Lawyers aren't magicians. They don't go to court and wave a wand and get a result. It's all about hard work and application before you go to court. That's particularly so in drug cases, in my opinion.